Well, welcome everybody. Welcome to the Vermont Urban and Community Forestry Program's Winter Webinar Series. Tonight's presentation is Vermont Tree Laws. It's a refresher. I'm Kate Fuller, and I work for the Vermont Urban and Community Forestry Program, which is a partnership between UVM Extension and the Vermont Department of Forest, Parks, and Recreation. I will be moderating this evening's presentation. Our presenter tonight is Paul Gillies. Paul is an attorney at Tarrant, Gillies, Merriman, and Richardson Attorneys. He joined the firm in 1993 after 12 years as Deputy Secretary of State for Vermont. Paul's practice involves most of the usual civil areas of law, including municipal, zoning, and land use, property, appellate, and trial work. He has a special fascination for old roads, boundary lines, right-of-ways, and other easements, and that special land where history and law collide. Paul serves as the chair for the Vermont Institute of Government, a nonprofit corporation dedicated to improving educational opportunities for local officials and the public. He is the author of numerous publications on how government works, including the Law of Trees, and he's our go-to guy with all questions about trees and laws, and we're very pleased to have him join us this evening. So welcome, Paul, and with that, I will go ahead and turn the microphone over to you for this evening's talk.
Thank you, Kate, and welcome everybody. I feel very much like a Luddite tonight because this is new to me, and I apologize in advance for any mistakes I make. But I thought maybe we could talk about the subject as thoroughly as we can, and I'm prepared to go through the statutes and also some leading cases and to suggest what town tree wardens need to do. Let's start with the creation of the office, and some of this is covered or maybe in that brochure of the Law of Trees. But the first statute is how are you created, how are you appointed, and that's found in Title 24, Section 871. As an aside, as an attorney, I stopped using the green books. I never thought it would happen, but I'm always on the net. I go to the legislative homepage, I scroll down to state statutes, and pick the particular title, and I've become very fast at that. I'd recommend that for anyone. It certainly beats. I love books. Don't get me wrong. But so if you were to scroll down to Section 871 in Title 24, you would find that you are one of the most important officers in the town, even though you're probably not thought of that way by your fellow officers. And that's because this section talks about when the select board first organizes in the first of the year, and they elect a chair and a clerk from among its members. And then the statute says the select board shall thereupon appoint from among the legally qualified voters a tree warden. And then it goes on to appoint other officers, most of whom have been forgotten or whose offices have no authority at all, such as the fence viewers, pound keeper, inspectors of lumber, shingles, and wood, and weighers of coal. This is different. So it's an appointive office in a town without the need for a special charter, and but you must be a legally qualified voter to do it. Now, if you were to scroll down to 1304 in Title 24, you would find that the general law relating to incorporated villages provides a different system. And in that case, the villages elect the tree warden. In fact, they shall elect the tree warden annually. Now, with villages, you have to be careful. If you're in a village, you probably have a charter. You almost certainly have a charter or some kind of document. And I wouldn't go to work in a village office without having a charter taped to my side anyway. So you would want to make sure that if there was no provision in the village charter for how to create a tree warden, then you would fall back on this statute. And then just because you probably didn't think this was a position that would amount to much in terms of remuneration, in Title 24, in that section within the tree warden statute, it does say that the municipality may appropriate a sum of money to be expended by the tree warden, and if one is not appointed by the mayor, alderman, selectman, or trustee. So it sounds like there's a backup if you suddenly didn't want to do it. Let's go through the general law, but before that, let me just take a minute and discuss discuss why the office is important. And I think for many years, the office has just been generally ignored. But there have been cases along the way, and more recently than there have in the past. The only previous case that I found was from 1928, and it's the sort of the old saw that everybody cites. But there have been 2 or 3, maybe 3 cases in the last 10 years that have brought new attention to the office. The idea is, of course, that a tree warden is a necessary figure in order to justify the cutting of public shade trees, and we should spend some time talking about what public shade trees are. I happen to know a little bit about this subject. I often talk about subjects I only know a little bit about, but I have actually litigated 2 of these cases. One which had 2 Superior Court hearings and 2 appeals to the Supreme Court, Hamilton versus Town of Holland. And I also had an active case in another town. And maybe I just start with that other town. I probably ought not to give the details because I don't want to embarrass anybody. But what happened in that town was that a woman had a great love for trees, and there was a big tree, I don't know what kind, out in front of her house, and it was on the other side of the street from a central park. She was very concerned about the tree. She bonded with the tree. She felt the tree was part of her family, if you'd say. And before she left on vacation, there were a couple of branches that looked like they were dying, and so she decided that out of an abundance of caution, she would go down to the town office and ask if there wasn't somebody who could, if they were going to trim the trees, she wanted them to hold off on trimming the trees until she got back so she could oversee it. I'm sure the road crew was pleased to hear that. But she left a message there saying, if you're going to trim the tree, I want to be here for it. And then she went away on a trip, and when she came back, the tree was gone. Not only was the tree gone, but so was the roots, and then it was gone. It was just a little dirt right over the thing. And she became very upset with this. And she learned that public shade trees cannot be cut down, with some very minor exceptions, without a hearing. And this is the essential part of your job. Yes, you have duties to ensure that the control of pests in trees and control of blight and all that. But the principal object of your job is to hold a hearing and then to decide whether a tree should be cut down or not. And of course, we're not talking about little saplings, but we do have to get to the questions in a minute of what constitutes a public shade tree. In the end, the town settled for a significant amount of money, 5 figures of money, to avoid a lawsuit or a decision in a lawsuit. And that's not money that went to the tree warden, by the way. That money came from the town to the lady, and I believe she then donated it to tree plantings of some sort. But just to give you a sense of the significance of this. Now, it doesn't always work. It's a protection. It's a law that allows individuals to have some say in the trees that line the public parks, or maybe in the most expansive way, the trees that cast shade on public property. But it can be used. It is frequently used as a tool against municipalities when the tree warden fails to do the right thing, such as in the case of the older case. I mentioned the 1928 case out of the village of Orleans. Let me just make sure I get it right. It's a case of Skinner versus Buchanan. And in that case, there were 3 tree wardens. You'll see in the statutes, if you look at the statutes, this is Chapter 67 of Title 24. You'll see that unlike most public offices, a tree warden gets to appoint deputy tree wardens. You don't have to go back to the select board. That's your power, and you have the power to dismiss them at pleasure. It may not be any pleasure, but it will. In this 1928 case, this was a tree, the two shade trees, a maple and a poplar, that formerly stood in front of premises owned and occupied by a lady abutting the easterly line of Maple Street in the village of Orleans. And the tree warden somehow misunderstood his job, and his two pals, a pair of brothers, went in and just cut this tree. They didn't have any hearing. They didn't do anything. And the village attempted to defend this case by saying, yeah, so what? And the court took it extremely seriously, and they held in the end that it was a mistake on the part of the town, and by that way the tree wardens, not to have held a hearing in front of before that happened. Now, take this in context. The safest way of defining a public shade tree is a tree which is within the public right-of-way of a highway, or within a public park, or on the premises of a town office. We're clear on those, I think, and we're very clear on those. And in a few minutes, I'll get to telling about Randolph and its cherry tree, I think it was, or a flowering crab or something, which has been the most recent case out of the Superior Court. But so we have now. We need to talk a little bit about the public right-of-way too. I'm sorry to ramble around like this, but it's necessary. You have a road in front of your house. It's 18 to 25 feet in width, depending on what kind of a major connector it is. The public right-of-way is the extent to which the village or town or state, in some cases, can control what goes on within that right-of-way. And most roads in Vermont are 3 rods wide, that is, measuring about 25 feet from the center line of the traveled way in either direction. If you are living as in most people in Vermont, you'll be living, part of your house may very well be within the public right-of-way. I know my office at work is, my particular office in the building is within the public right-of-way of the street I'm on. Now, that doesn't mean you have to go out, and doesn't mean that the town's going to bug you, but it does mean that trees within that area will probably be subject to some control and some process that needs to be followed to the T, or the municipality will be subject to some liability. You personally will not be subject to liability if that's concerning you at all, unless, of course, it can be shown that you're cutting the tree down because you don't like the person who owns that property, or for some improper reason. But so we're going to go to the statute now as we slide around here. But anyway, so we're defining the public shade tree as those trees within those areas. So we have the statute in Chapter 67. It says the operative sentence is that the tree warden may remove or cause to be removed from the public ways or places all trees and other plants upon which noxious insects or tree diseases naturally breed. So this is part of your overseer role in protecting the health of the trees. And then it goes on to say, however, when an owner or lessee of a budding real estate shall annually, to the satisfaction of the warden, take care of that, then you're not engaged in having to do any work. You can get, in 2507, you can enter into financial or other agreements with the owners for the purpose of encouraging tree planting and preservation programs, and cooperate with governments to do that. But the most important section in the whole chapter is 2508, which says, unless otherwise provided, a public shade tree shall not be cut or removed in whole or in part, except by a tree warden or his deputy. This is not a become gender neutral as the way as the rest of the statutes are, or by a person having the written permission of a tree warden. This isn't going to go very well with a lot of people. People accept the fact they might have even have planted that tree, but that doesn't mean they have a right to cut it if it's in the public right-of-way. People get incensed when they hear that they don't have the rights they think they have, but I don't want anyone to feel guilty if you've known that trees have been cut within the public right-of-way and you didn't have anything to say about it, and I wouldn't go to war over it unless it was an extremely important case. But you can see that, well, trees are important. You need to have a hearing, and that hearing would not be satisfied, according to the Holland case, which we'll talk about in a little while, unless you have, it won't be satisfied if it's the select board having the hearing. You need to have a public hearing by the tree warden. That means you would warn it. The statute doesn't say any details about warning it, so I would assume that you would do as much warning as you can, posting the time, date, place, and purpose of the hearing, signed by you, posted in 3 public places, and that's probably enough. You don't have to put it in the newspaper, but you would certainly want to send it to anyone who's interested. So certainly the owner of the property, certainly the owner of maybe the neighbors of either side. Now, you don't have to have a hearing. You can go right ahead and cut down a tree if it's infested with or infected by a recognized tree pest. I'll leave that to the extension system to tell you what that is. Or when it constitutes a hazard to public safety. So the old tree is leaning right over, about to fall on the next car, that can be taken down without the hearing. And certainly in any emergency situation, you shouldn't be hesitant to have it cut down. As I see that tree falling, I think, utility lines, and of course you have to be careful about that too. And you may want to even have the utility company present at the time. Your decision is final, which is really unique. In all cases, the decision of the tree warden shall be final, except when the tree warden is an interested party, or when the party in interest so requests in writing, and then you have a final decision to be made by the select board. So that must raise the question of what is an interested party. That means, well, if the tree's on your land, or if the tree's on we will go to the traditional conflict law, which is within the 4th degree of consanguinity or affinity. That means blood or marriage. So 4th degree, you're the first, your mother's the second, your brother's the third, your nephew's the fourth. So you got the nephew or the first cousin, any of that. Or if you happen to have a financial relationship with the person who's requesting it, or whose property is owned there, or if you had if you just didn't get along with them. If you were their enemy, or if you were their friend. And I wouldn't try to get around that. If there was any suggestion that you were an interested person, then I would say, I'm just passing this on to the select board. They're the ones who were elected to take the heat on this. So the rest of the statutes really are relating to infestations of plants and things. How aggressive should you be? That's sort of up to you, I guess. One of the most important things, I think, in handling the role of the tree warden is to try to figure out what, just to ensure that the road crew and maybe the police department and maybe the town as a whole, maybe you're going to write a report in the annual town report explaining what your job is and inviting people to call, making sure the town clerk in particular and the select board understands what your job is. After you've been appointed, they will be appointing people blindly to offices that they think are of no value. And I wouldn't hesitate to maybe make an appointment, come in to see them at some public meeting and explain that you've read the law and you know what's going on, and that people should know there is a tree warden, and that the town in particular, particularly the road crew, should be sensitive to this before they go hauling out the chainsaws and start cutting things up. By the way, common law in Vermont on the owners on highways, which we follow through on this, is that if you do cut down a tree, you are obliged to offer the wood to the landowner of the underlying fee. Let me go back a minute to public right-of-way and just say that you have you don't give up all interest within the right-of-way. That's what that offering the wood to them reflects. If you are, but when a piece of land is superimposed, has the easement of a public right-of-way superimposed over it, that gives the select board, and in some respects you, full authority over what goes on within that 49.5 feet. By the way, not all roads are 3 rods, and if you have an old roads committee in your town, you probably want to check to be sure what the width of a road is. There are, for instance, any road that led to another town is more than likely a market road laid out by the legislature at 4 rods, and some roads which are connective roads from, 2 major town roads, they were allowed for many years to be 2 rods wide. I have seen 1-rod roads, town roads, in the town of Rochester, and I have seen 8-rod roads in the town of Stratford, I think it was. And there has also been, the traditional width of railroad rights-of-way was always like 6 rods. So you've got to keep thinking of that so you know the extent of your jurisdiction. But stopping somebody from cutting is the first thing. You want to make sure that if something goes on, that you don't get yourself, you want to, once the tree's cut, then all there is blame for you.
Paul, this is Kate. I just wanted to interrupt you. There is a question in the chat box from Vincent. I'm
sorry. I can't talk and look at the same time here. So Vincent writes, what is a homeowner's liability regarding trees on their property that might fall into the public right-of-way or neighbor's property? Well, I guess it depends. If you walk out one morning and you see a tree leaning over in a big crack and it's about to fall, or you have some feelings about it, as a homeowner, I think you avoid liability by calling the tree warden. The negligence, it won't be a direct negligence of the individual landowner if somebody has been alerted. And if you've done the best you can, I suppose if there was a big storm coming and you knew it was coming down, I still think it's a bad idea for you to go out and cut that tree. There are too many risks involved. I would make a formal request for action by the tree warden, copy it to the town clerk and the select board, and I would probably try to put that in writing so that they understood, dated and time, so you know what's going on. I know these things happen. In fact, I was really surprised recently. I was reading the early history of Montpelier, and they listed all what they called unnatural deaths, which would be deaths other than disease, I guess. And the majority of them were deaths from falling trees. Gregory Sanford says that that's more common than you'd expect, and that the early Vermonters, imagine a place where there are trees everywhere, huge trees banging up against each other, and you've got to clear your land. Well, many of you have been in the woods, and you know what it's like to have to deal with so-called widowmakers that are in the middle of a dense forest. But it's nothing to fool around with, and that's why we have professionals to do that. By the way, just because the statute says that you have an obligation you're the one to cut it down, that doesn't mean you can't hire a company to do it. Don't feel as though they've just enlisted your chainsaw. It's under your direction. And you remember I had read that it said that it was in whole or part or something of that nature. So it's possible that there's just a wing of it somehow that's dying and dead, and you can cut that out without killing the whole tree. I don't know, have you ever seen pictures of Montpelier, what it used to be like with all the elms, and Burlington, of course, and it's really one of the great disappointments of time that we had that elm disease and that it killed all those trees. But trees are coming back, and trees make all the difference in the world, as you know, about whether a town feels like a homey place. So I've been talking for almost half an hour here, and I just want to finish up with a couple of things, talking about the cases that have been recently decided. The leading case in Vermont, a more recent case on Vermont at the Supreme Court level, is Hamilton versus Town of Holland. This was a road. I'm always interested in the background of it. I was the attorney for the town. The individual who was the plaintiff sued the town. The case went on for, goodness, it must have been 4 or 5 years, and it was considerably arduous. The town had originally planned to open up a highway so that as the town testified, the trees had grown in so much in this older town highway. It's a Class 3 highway that the school bus drivers had to call ahead on their radios in order to know who was going on the road, because it wasn't wide enough for them to pass. And one gentleman had a home on that road, and across the street from his home was the biggest, fattest old tree I've ever seen in my life. It might have been 6 feet in diameter, and it might have been an elm or something. It really didn't even look like a tree. It looked like some aberration of nature. And in fact, it was just this big lunk, and they had some little stringy branches coming off it. It wasn't dead, it wasn't dying, and it really wasn't likely to be cut. But I think that was what triggered his interest in reacting to this. So he sued the town. First he made a complaint, and the select board met, and they invited the tree warden to come along. So they had a select board hearing with the tree warden present, and then he had appealed that to the Superior Court after that decision was made. And in the meantime, then the town scaled back the program and decided that they were going to do just a little bit here and a little bit there, not near his house at all, although they did cut some trees on his house, on his land. In the case of the first go-around in the Superior Court, the question was, he took the case to the Vermont Supreme Court, and there they decided that they weren't finished with it, so they sent it back to the trial court again after oral arguments, in which the Chief Justice seemed to make it very clear in oral argument that he regarded every tree that cast shadows on public property would be governed by this. The whole process, the whole judicial process, was apparently regarded the fact that the tree warden hadn't held his own hearing as something of a great mistake. And so in the end, the trial court, when we went back to the court, agreed with the town to the extent that the trees could be cut, but gave damages to the landowner of $1 in nominal damages. That's usually you won, but you don't get anything. But also $15,000 in attorney's fees, which didn't feel as much like victory as you might have thought. On appeal to the Vermont Supreme Court, that was struck down, and the process was over, and nobody paid anybody any legal fees, and the case was dismissed. And all it matters now, the work's been done, the road's opened up, the school buses can cross without problems, and anyway, the decision of the Supreme Court in the Hamilton case did come to a definition of a public shade tree within the residential parts of a municipality may not be cut down without a public hearing unless the tree is infested by pests or is a hazard to public safety. Ironically, we had tried to make the case in the Hamilton, make the point in the Hamilton case that it was a matter of public safety, but to the court it sounded like an after sort of an excuse, and it didn't seem to work. The other case, which I want to mention is the case of Kevin, K-E-V-A-N versus Town of Randolph Select Board. This is a decision in the Superior Court, so it doesn't have the same weight and bearing as a Supreme Court decision, but it involves this flowering crab apple tree that I believe is still in front of the Randolph town office. The town announced that they were going to cut it down, and the tree was regarded as an exceptional tree with importance in the community, and a number of different residents came forward and opposed it. There was a hearing by the tree warden. In that case, they published the notice in the Herald of Randolph, and a written decision was issued, and that was appealed to the Select Board. And the Select Board held a public hearing, and at that hearing, they heard all the evidence. In this case, the Select Board went into executive session to deliberate, and one of the side aspects of this is that the town was roundly criticized later on for having entered deliberative session, which is possible after a so-called quasi-judicial hearing, where you just meet without need for notice, and was criticized and blamed significantly for doing it within an executive session, which is a closed session within a public meeting. You don't have to worry about that. You don't have to have public meetings. You are bound by the public records law, however, so any piece of paper you have relating to your official business, you cannot destroy it. You must keep it, and someone could get a copy and review it if they wanted to. So in the end, in the Randolph case, let's see, they reversed the Select Board's approval of cutting the flowering crabapple tree, and they said they have to have a proper hearing. I don't know what happened to it after 2006, but as I recall, I think I saw that recently when I was down that way. I may be wrong. Just a way of maybe telegraphing the importance of your office and the importance of the hearing. Maybe a word or two about the hearing itself. I'm thinking you will want to have, because it's a quasi-judicial action, that means you're acting like a judge. You're going to want to have someone present who is capable of swearing in witnesses before they testify. You should allow people to testify and under oath, and also and you should listen to what they have to say. And if there are parties, such as, say, people that happen to own half a tree, maybe splits their line, and they would disagree, perhaps, then you would want to allow cross-examination, or just you can ask questions of the other person. Then you would want to ensure that you didn't talk to any of them before or after the hearing about the subject, so you were keeping yourself impartial, avoiding what they call ex parte communications. And you'd want a written decision in which you broke it down into 3 parts. 1, findings of fact. 2, conclusions of law, where you would cite the law that we were talking about in Title 24. And finally, and then a decision, simple decision with a note saying that you have the right to appeal to the Select Board if you don't like the results. So, how are we doing here? Are there more questions? I haven't seen anything lately, or if I haven't missed it. Is there a difference? I'm sorry, here's one. Is there a difference between maintenance pruning and cutting as a legal matter? I would, I guess pruning, like, you're just cutting the limbs off because it's growing into the sidewalk. I don't think there's any occasion for you to be concerned, unless, of course, it was done so badly. One time there was a cedar hedge out in front of our house, and I thought I would go out and trim it a little bit, and I was horrified to discover that whatever I took off wouldn't grow back. So it depends a little bit on the species, I suppose. But I would think this is something serious. If you've got a 2-foot diameter tree and there's a 1 foot that splits into 2 at some point, and 1/2 is dying, and you're going to cut that 1/2 off, I wouldn't call that maintenance. I would call that more like cutting. But if you're just pulling back some branches, that's just not going to trigger anything. Of course, the most dangerous characters, as far as you're concerned, are probably the town road crew. and there'll be some days they'll be sent out and wanting to do something like a spring cutting, and it wouldn't be a bad idea to have, for them to be sensitive to it and to have your phone number, cell number maybe, even if they're out there and they have a question. It's far better to do this in a prophylactic way than it is to do it, after the fact. Once you've cut, it's really a shame. It's nothing that can be done other than to bring in the lawyers and sue everybody, and nobody wants to do that. It's not a law that is intended to be the subject of lawsuits, and it's unfortunate. And it probably, whenever there is a lawsuit, it probably represents the failure of proper consideration for the laws. My last topic is to be laws regarding private trees, and I might turn you over to the pamphlet you may have seen called the Law of Treason. And writing that pamphlet, I had an awful lot of fun. I have the advantage of having access to all the Supreme Court decisions of Vermont, or the whole nation if I wanted to, but I mostly stay in Vermont. And the reason I have that, what I'll do is just put in tree into the search engine and follow it wherever it goes. And so there were lots of questions that I wanted to answer for myself. What happens when the neighbor's apple tree spills, drops apples onto your land? Do you get to keep the apples? What about the root that comes up in your driveway from the neighbor's tree? And I won't pretend to remember all the answers to those, but they're all in there. And I'm particularly fond of the story that goes with that on the bee tree and what that says about property. I see we have another question. Thank you. Does a tree warden have the power to deny a request by a utility to prune? Well, again, I suppose it goes back to that previous question of whether pruning is different than cutting. Across the street from my house, there's a line, and the utility came in a few years ago with some kind of one of those tall chairs that goes up and down, and they cut every branch of every tree from 12 feet up to 20 feet up so that they wouldn't interfere with the power line, and leaving the top and leaving the bottom. And I can't say that it looks awful, and I would have said, had I wanted to make an issue of it, that would have been a case where I might have brought the tree warden in beforehand. I've insulted utility company maintenance people more than once, in that Hamilton case by making perhaps the false assumption that they are a bunch of cowboys. But I've also had people tell me that they've had that experience themselves. So but the right to prune trees, or the right to maintain the lines, is something that the select board routinely grants, and many times the utilities don't even bother to ask. So I would start with, again, your little visit to the select board at the beginning might very well be that, and maybe a note to the utility company as well, that you're in town, this is your job, this is your responsibility, and you're taking it seriously. So if they're going to do any serious cutting or pruning and that sort, other than just surface kind of cutting, they need to talk to you, or else. I don't know what else is, but else is that it's the law and everyone must obey the law. I suppose the principal contact would be the select board, or if you have a manager. I don't know whether mayors listen to this stuff or not, but you got to be known. This isn't a job like the waiter of coal where you go home and watch TV. This is an active job, and many tree wardens that I know take this extremely seriously, and the communities are appreciative. Not that you'll be well loved in every situation, but let's see what else. When I talked about the laws relating to private trees, by the way, I'm really talking to everybody, not necessarily tree wardens. You're not responsible for picking up the apples from one private property to the other. Your job is entirely related to the public, the world would be land owned by the public or controlled by the public through an easement. I see we're reaching the 45-minute mark, and I'm thinking that if you have other questions that you want to ask, this would be a good time to do them. I did see one other case, by the way, and this was an environmental court case. I just ran into it the other day, just recently. And in that case, this was the Birchwood Land Company final plan approval, a 2005 case in relating to the subdivision in the town of Essex, in which the judge made some findings and made some orders about how this particular subdivision should be developed. And it's just a surprise to me, but in terms of the preservation of natural assets section on this appeal, the zoning permit appeal, the judge essentially ordered this. He said the final plan submission indicates a row of street trees bearing little relationship to the vegetated buffer described above. The existing development along Tanglewood Drive and Rosewood trails characterized by mature trees and vegetation is described in finding S. The town tree warden must be consulted about how to preserve existing mature trees in the street facing vegetated buffer, and how to properly plant street trees without unnecessarily disturbing the mature trees and vegetation. And then he says, no, it's acceptable to use existing mature trees as substitutes for the planting of new street trees. However, the town tree warden needs to be consulted as to the specific selection of those existing trees. So this is unusual in the sense that, first of all, that the court is even aware that there's a tree warden. Maybe it came up with the pleadings, but we're talking about the tree warden's duty in a new subdivision, in a way in which the people might be who are developing it might have no idea about how to put that together. And so here we have, a subdivision in which some of the roads will be treated as public roads, and so we're getting you involved in the subdivision and development process. So I wonder, are there any more questions? Does anyone have any questions? Yes, we have another. Are the laws similar regarding private easements through adjoining properties? It's a great subject, and I just want you to take off your tree warden hat while I'm talking about this, because this is something that involves private land ownership. But I'll give you a short version of this. In terms of private easements, well, first, what is an easement? An easement is a right granted by one party to another to use the first person's property for, say, spring rights, water rights, right-of-way in the sense of an access through or a utility lines. And one of the great frustrations for a lot of people is the private rights-of-way that don't necessarily include the express permission to develop a utility line. They may be out of luck. There's an argument that can be made against that, but generally speaking, that's not going to work very well. There is, and there have been in the past, easements on the preservation of trees. I have a nice view when the trees are growing up. I go to my neighbor and I get a deed, just like a deed for anything, with an acknowledgement, and it says I get to cut the trees so I can enjoy the mountain view. And that's entirely possible. But unlike other states, Vermont has, as one old justice once said, not adopted the doctrine of ancient lights, which is to say that if you're in probably you're going to be in a village for this. You're not going to be out in the woods. But if you're in a village and the sun comes in from the east in the morning and you love it and it's in your yoga room and all that, and then the next day the guy next door who has a very close, this short setbacks under the village zoning bylaws, erects a 3-story house that shuts off the light to your house, you don't get any. You can't complain. It's there's no right to light, in other words, so they could box you right out in that way. So generally speaking, private easements are it's a pretty vague law. I mean, it's adaptable, so it doesn't want to be too specific, but they aren't entirely alike, and there's no real actor such as the town tree warden to work them out. But I don't know, Bob, if there's a more specific question you had, but that's the best I can do under the circumstances. Somebody ought to write a pamphlet about that. Okay, Kate, what can be done locally to define shade tree? What is the real difference between a tree policy and a tree ordinance? Well, let's start with the last part of it. An ordinance is something that's duly adopted by the select board after proper notice, and that proper notice must include, it's a sort of backward system. Instead of asking the voters what they want to do, you do it. You adopt the ordinance, and then you invite them to petition to disapprove it. So it's more of a default kind of mechanism. But policy is a word that's, at least in the legal context, means it isn't enforceable, it's just some good advice. So if you're going to do something, you want to have some muscle behind it, it would be a tree ordinance. Now, of course, the real question is there authority to adopt such an ordinance? And we have 2506 in Title 24. It says that the tree warden shall enforce all laws relating to public shade trees and may prescribe such rules and regulations for the planting, protection, care, or removal of public shade trees as he deems expedient. It relates you to Chapter 59 of Title 24, which is the basic ordinance matter. So the legal difference between the tree policy and the tree ordinance, there is a big difference because you don't have the ability to adopt a tree policy, only a tree ordinance. So you want to study and particularly you want to study the aspect of what is a proper warning for that. The language is within the statute, you can lift it out, but you're going to want to make sure that the statute that gives notice of these ordinance adoption provides for a clear, first of all, you would want to publish the ordinance in the town, in the official town paper, and you would also want to let people know that 5% of the electorate, if they found it objectionable, would be able to undo it. I don't know that I would try to define public shade tree unless I was quoting one of these cases or the statute itself, because I think that you may be, if you use the ordinance to define public shade tree, you may be working beyond your authority, and that may be a delegation problem. But of course, no one's really provided any real good definition, so you could do it. But there's a great temptation, of course, in adopting ordinances to go through the statute and make the statute part of the ordinance. Doesn't make it any more of a legally binding matter, but the purpose of the ordinance, I suppose, is so that people will understand what's going on. And, probably, if that Law of Trees brochure didn't do it, maybe what some enterprising organization ought to do is a little brochure that you'd have available to town office saying, hey, say you want to cut a tree down in the public right-of-way, what to do. There is another pamphlet, by the way, from the Vermont Institute called The Public Right-of-Way in You, I think it is, which has been kept up and is in pretty good shape. And it could be used to help you understand that as well. So how are we doing? Any more questions? I don't see any. I want to give you a last call here. Shall we say, anybody else have something to do? If you're typing, I'll wait. Otherwise, maybe it's Kate's turn to come back.
Sure, Paul. I'm just taking a quick look at the participant list, and I don't see anybody typing. So I think that that might be all for questions. I'm just going to double check here. It doesn't look like anybody, there are any additional questions coming in. So let's see here. Let's just wanted to take the opportunity to thank you, Paul, for joining us tonight. I'm playing catch up because I've been taking lots and lots of notes during your talk here. There's lots of great information, and we certainly really appreciate you taking the time to join us. You know, you really are the go-to guy on trees and laws, and I really appreciate you taking the time to share your experience not only with the law of trees but also with all these cases you know, that you've seen come up around the state. So thank you so much for your time this evening. Just wanted to let folks know that there is an evaluation of tonight's webinar, and we really do appreciate your feedback. So I'll go ahead and drop this link in the chat box, but if you have a second before you sign off this evening, if you could just go over to this evaluation and just let us know not only how we did tonight, but also what are some other topics that you would like to see us bring to you via these webinars. We'd love to know. So please use that to let us know. And then just a quick reminder, our next webinar is scheduled for March 20th, and we'll be joined by Paul Rees out of the Oregon Urban and Community Forestry Program, and he's going to be talking to us about working effectively as a town, as a tree board, and his talk is titled 7 Habits of Highly Effective Tree Boards. So with that, I don't see any other questions coming in, and so I think we can go ahead and thank everybody for your participation tonight. Like I said, Paul, I really appreciate you taking the time to join us, and hope that everybody has a good evening, and thank you again for joining us. I'm going to go ahead and put that link right now in the chat box. So go ahead and click on that link. There it is there to find your way to the survey of tonight's webinar. That's it, folks. Thank you again, and have a good evening.